purposes of a hearing relative to Chapter 241 of the Town Code. With that, I'll make a motion to begin the hearing. All in favor? Any opposed? Hearing is open, and I will turn it over to the town attorney.
Thank you, Mr. Supervisor. Did we get rid of the echo? Okay, good. I'd also like to thank Mr. Borak. This afternoon's almost here at the 11th hour, our chief of police made known that he wasn't going to be able to be here in person. So
recording in progress.
So he has made accommodations so that we can proceed with this while he appears virtually. So thank you, Mr. Borak. We are here for a hearing under section 241.19, appeal and hearing in the event that the chief of police refuses to renew or revokes or suspends a letter of authorization. The authorized town tower shall have the right to appeal such refusal, revocation, or suspension to the town board in accordance with the following provisions. And there are provisions in there. The hearing was requested after our chief of police failed to renew, and we are here at Mr. Borak and his client's request for this hearing for due process. Is there anything you'd like to add before I go forward?
Yes. We're here because we sued the town to get the hearing under both 241 and Town Law Section 137. And Mr. Mustafa's license was not failed to renew, it was terminated in January of 2024. So we're here for provisions, the town law requires, the town law and the state law both require the town board to make the determination of any revocation, suspension, or failure to renew. And we've got a stipulated order requiring the hearing under the provisions of the Article 78 proceeding that you brought, which relate to both Section 137 of the New York State Town Law and Chapter 241 of the Town of Cheektowaga Code. We all set to proceed?
We are ready.
Okay. So I've given each of you council persons.
Do you want us to go first and present our proof, or do you want to make argument before we proceed?
No, we're going to make our presentation.
Without us putting on any proof? That's fine by me. Go, feel free. Thank you.
Yep, we're going to make our presentation. I've given each council person a binder which has 26 evidence tabs, and I've given the court reporter a copy of each of those exhibits in full. Your binders are printed in duplicate with the exception of the exhibit cover pages. So you'll look on each page, front and back. Each page is numbered beginning with page 1 through the remainder of the documents, I believe 196 of them. So when we refer to page numbers, it'll be easier than having to say exhibit 3, page 6. It'll be just page 65, whatever. First item I have in the exhibit folder is a copy of Chapter 241 of the Town of Cheektowaga Code. This is the section that deals with the issuance of licenses to town towers by the Town of Cheektowaga. It is the chapter under which Mr. Mustafa was given a license as a town tower by this town board back in July of 2022. We have an exhibit that shows the resolution. It's Exhibit 2 with Resolution 2022. That exhibit starts at page 12. The exhibit itself is page 13. But let's go back to the town law itself because I want to highlight some information in here. Your town code itself has a very serious problem that impacts on my client, Mr. Mustafa, and just code. Section 241-6 of your town code, paragraph 16, states that permission for the Cheektowaga Police Department to conduct a fingerprint criminal history record investigation of the owners and drivers must be provided for any applicant, which Mr. Mustafa did. He provided that. Each owner and driver will sign a waiver Such fingerprints will be forwarded to the Division of Criminal Justice Service along with the appropriate processing fee, which your chief of police did. But then it says, authorization will not be granted to an owner or driver convicted of any felony. That provision in your code is absolutely unlawful in New York State. Absolutely no question. We're going to get into the specifics of that when we get to your allegation as to why he shouldn't have his town tower's license because he employed a person who was convicted of a felony 25 years ago. All right? And we're going to show that that provision is absolutely unlawful. It's unlawful not only in New York State law, it's unlawful under federal law. The EEOC has a specific example, and we have that in our exhibits, we'll get to it, that shows you that you can't provide that. You can't have that provision. And this provision, by the way, this unlawful provision about not authorizing someone with a felony, that's also in your peddler's license law. You have a problem with that too. But as pertains to this particular issue, it's in the town tower licensing law, and it doesn't belong there. On page 10 of the documents, still within section 241 of the town code. Section 241.17, audits receipts. 241.17A, and excuse me, I have a bit of a sinus infection. 241.17A requires receipts to be provided weekly, on a weekly basis, invoices to be provided to the police department on a weekly basis, which my client did with the exception of about 6 weeks. It was an issue. We're going to get into that as to why he didn't do that. But it's important to understand that this is a requirement for all town towers, just not for Mr. Mustafa. It is in every town tower license that's required. And the reason that becomes important, and we'll get into the details on it, but we asked you for copies of the receipts of a particular town tower for the last 3 years. We got back a certification they don't exist. Now I want you to think about that. Mr. Mustafa was a little bit late with some of his invoices going to the police department by about 6 weeks. But you have a tower out there who hasn't provided one invoice in 3 years. 3 years. And you want to take away his license? And then on top of that, of all the irony, when you took away his license, you gave his territory to that tower, who's not providing any invoices, completely violating the law and the authorization. Section 241.18, revocation of letter of authorization. Now this is under section 241. Prior to the annual expiration date. Prior to means before. I'm not confused by that. I don't think any of you are either. It doesn't mean after the expiration date. His last tower license expired December 31 of 2023. Yet, the chief of police continued to operate with him under that license. In New York State, we have what's known as a course of conduct. And we'll get into that soon in the future too. When parties are in an arrangement that has an expiration date, but they continue to deal with each other in that arrangement, New York State law imposes a course of conduct relationship. Now you can still revoke that course of conduct. You can still say, yes, Mr. Mustafa, we were engaged in a course of conduct with you as a town tower after January 1 of 2024, but now we want to revoke it, so then we're going to have the hearing, etc. That's fine. But you can't go back and backdate the non-renewal. You didn't not renew it. You didn't do that. You can't now go back and say, oh, but that's what we're doing now. That date's passed. December 31st, 2023 is gone. You can't go back and now say, well, we're going to make believe we didn't renew it back in December, when in fact that's not what you did. And the law requires you to do so. And also when we get into the town tower authorization license, you'll see it also requires that you do that. 2419, appeal and hearing. A refusal to renew or revoke or suspend a letter of authorization requires that it shall be determined by the board after a hearing. Again, after a hearing, not before. So the police chief can tell you, I think we should stop dealing with this person. But you have to make the decision, not the police chief. It's your decision, and you have to make it after a hearing. You don't get to suspend, revoke, or failure to renew before the hearing. That's clear under the town law. It's also clear under the New York State law. Exhibit 2, as I mentioned, is just a resolution for the record. Exhibit 3 is the towing letter, authorization letter, specifically for Just Tow It, Mr. Mustafa's company. And if you turn to page 17, paragraph 7 of the authorization letter, annually, before the expiration date of this letter of authorization, it says that the chief of police will notify whether or not it's going to be renewed. Not after the expiration date, before the expiration date. That wasn't done. There was no notice sent in before the expiration date. Page 18, this is going to become important later on as we go through this too. And this relates back to the problem with your law being illegal. The reason you cannot have a blanket no felons hired provision in your law is because under New York state law, you cannot discriminate under the executive law against someone solely because of a conviction. There are two conditions. If you can determine if they meet one of two conditions, then you can then say, okay, we're not going to hire them. But to reach those two conditions, you have to apply 8 factors, 8 specified factors. So you can't just simply say, oh, because you're a felon, no, you can't be here. You have to go through the process. Chief of police didn't go through that process. Your law doesn't go through that process. Your law just says, we're not giving you a license if you're a felon. But interesting, right in your letter of authorization, right in the very letter that you require him to comply with, paragraph 14, your firm will not discriminate. Your firm will comply with provisions of section 290 to 299 of the executive law and the civil rights law. Section 292.15 says you can't prohibit felons from being employed or refuse to give a license to a felon, solely because of the felony. So you require him to follow that law. Then you go out to him and you say, we want you to violate the law. And if you don't violate the law, we're going to pull your license. You put him in a no-win situation. If he does what you want him to do, he's not only violating the law, he's violating a license. Absolutely improper. Exhibit 4, page 21. This is the termination letter. Issued on January 26th, long after the expiration date in the existing letter. But it says in its own terms, not that, oh, by the way, we didn't mean to renew your license, so please stop responding to our calls. No, it says, we're going to revoke your license 2 weeks from today. We're going to continue to use you for 2 more weeks. Then we're going to revoke your license. And that's fine, you can say that, but you would have had to have that hearing both under 241 and section 137 of the state law before that date. You didn't. You simply didn't. This letter should have said, we're going to revoke your license, the town clerk will inform you about the date of the hearing. That's what your letter should have said. Exhibit 5, page 23. This is the New York State Town Law, section 137. After a public hearing thereon, at which the licensee shall have an opportunity to be heard, the town board may revoke any license issued under the authority of this article. And this article replaces all licenses issued by local governments and state governments, etc. And of course, it's subject to certiorari review. So no matter what decision you make tonight, if Mr. Mustafa thinks that it's an improper decision, we can also go to court and ask the court to review that, but that's not what is issue here. What an issue is whether or not you should revoke it in the first place. But again, you had to do it before. And by the way, the lawsuit includes a claim for incidental damages. Those incidental damages are all of the receipts he would have gotten from February 9th until you make your decision. So let's say you make a decision tonight that we're going to revoke Mr. Mustafa's license for whatever reasons you may decide to credit. And let's say the court says, you know what, they were right, they could do that. That's what it wasn't so outrageous that we're going to overturn it. Fine. You still owe him from February 9th until you made that decision, the date you made that decision. Because you should have been using him as a town tower during that period. And that claim is still pending before the court. Exhibit 6. Excuse me. Exhibit 6, starting at page 25. These are emails from Mr. Mustafa to various town representatives. We'll go through each one of them in a minute. In which he was asking about, can I have a meeting? Can someone tell me why you're taking my license away? He even asked in a couple of these for an appeal. The very words in section 241, he says appeal, I want to appeal this. And no response, nobody responds to him. Just ignore him, totally ignore the law, totally ignore him. February 1st, he writes to Christopher Beelan. And he says, can I have a meeting about this? That's a request for a hearing by a resident who's not a lawyer. That's a request for a hearing. Can I have a meeting? He's requesting a hearing. February 12th, he writes to, and I might get these, if I get these names wrong, you want to correct me, please do so. Sergeant Bizdiak, is it? Bizdiak? On February 12th, he writes again, can I have a meeting about this? Can someone talk to me? Tell me what's going on? No response. On March 6th, he writes to Supervisor Nowak a long, lengthy email, not only in which he asked for a meeting, but he asked for an appeal. And you don't respond. You just ignore it. As if Section 241 is meaningless, as if the provisions of 241 mean nothing. We're just not going to respond. We're just going to stop using you. He writes to Coons, asks for a meeting, and mentions appeal. Again, nobody seems to care about giving him his rights under the law. He's just going to ignore it. That's at page 30. Page 31 is the email, and I've highlighted in red. You'll see it probably in your copies. They're not in color, so you just have to look at the outline. If you can aid in either appealing this decision or at the minimum giving me a straight answer. That's all he's asking for, and you're ignoring him. So he comes to me, and he says, Mr. Bork, what can I do? They took away my license. They won't tell me why. They won't communicate with me. They won't give me a hearing. They won't tell me appealing. Nothing. Get nothing. And so I said, well, let me try and communicate and see what I can do. So I start my communication. I've included a copy of my affidavit about my communication here. It's filed with the court, but I've included it here so we can go through the particular facts. On April 25th, I called the town supervisor's office to ask about the grounds for the termination and ask for the hearing that he's entitled to. I spoke with Jennifer Craig, the supervisor's administrative assistant. Am I correct? She's your administrative assistant. Right. She said she would ask the supervisor to look into the matter. This is on page 34 of the document. On April 29th, I had a follow-up telephone conversation with Jennifer Craig, who told me the information had been sent to the law department. I assumed that meant town follow-up. I heard nothing further until May 20th, almost a month later, when I got a call from Jennifer Craig, who said, okay, we'll get your hearing on May 28th. And I said, whoa, wait a minute, hold on. We are entitled to 10 days notice, number one. We're also entitled to all the documentation we requested. We're also entitled to know ahead of time, 10 days before, the reasons why you're terminating it. You just can't call us in and come into a hearing and listen to what you have to say. We get an opportunity to prepare for it. And I had on the 26th filed a FOIL request for documentation. We're going to get into that in a minute. And I said to Jennifer, when you give me the response to the FOIL request, we can have the hearing. She said, okay, I'll see if the supervisor can speed that up. I hear nothing until June 6th, when I get a denial of the FOIL request. A denial that is absolutely improper. No questions asked about it. And we're going to go through that and the reasons for it. My FOIL request, Exhibit 8. Cover page is on page 38. The particular items requested on page 39. I asked for materials regarding Mr. Mustafa and just tow it. And in paragraphs 4 and 5, I asked for materials in 4 specifically regarding merge. I asked for all correspondence, written or electronic, to or from the town or any agency or department regarding merged fleet. I asked for correspondence, minutes, and other documents regarding any revocation, rescission, refusal to renew, or suspension of any town toll, any level, all 7 of them. And then I asked for copies of all authorization letters. I get back a response saying, we're not giving you any of this because it's under criminal investigation. All town towers under criminal investigation? First, that exception in the Freedom of Information Law only applies to documents created during the course of a criminal investigation. It does not apply to documents that exist separate and apart, even though they may be used in a criminal investigation. On page 40, I cite both the New York State Committee on Open Government FOIL regarding that, and a specific case, King versus Dillon. In King versus Dillon, the district attorney started a grand jury investigation, took the village minutes to the grand jury investigation. And when a FOIL was filed for him, he said, oh no, they're part of an investigation. And the court said, no, those minutes exist separate and apart. They're not created by the investigation. You can't raise this claim of subject to a criminal investigation to protect those documents. You have to give them to them. Every one of the documents we requested should have been given to us. This is a complete spurious, false, and inaccurate claim, an attempt to simply delay Mr. Mustafa from getting this information. And that's why, when we finally appeared in front of the judge told your outside counsel, get them the documents, get them the hearing. They're entitled to it. And come back here and report on the status. Now let's get into the weeds a bit. We filed a petition, the Article 78, asking the court to require that you provide the documentation, that you hold the hearing, and that you be held liable for the incidental damages. The court has not addressed the incidental damages yet, though they have to come. But the court did address the hearing and the documents and told your attorneys to agree to a stipulated order to hold the hearing and provide the documents. And so we drafted a stipulated order to that effect. We'll have a copy of it in here. We'll get to that in a minute. But I want to address something in here. In the petition, paragraph 11 at page 43, we allege that respondent failed to respond to petitioner's request for a hearing regarding the termination of its town tower license. That allegation is based upon both the emails sent by Mr. Mustafa and the phone calls in my emails. There's no question they were done. That's an allegation that you can't dispute. And you didn't respond to it. All right? But you filed an answer, a verified answer, under oath, that you had no knowledge of our requesting a hearing. How do you sleep at night? But here's the interesting thing about that. Because we filed a verified petition, which we're required to do under the law, you have to file a verified answer. That means you have to verify under oath that what you're saying, to the best of your knowledge, is true. Now, you may be mistaken, you may make it, that's okay, but to the best of your knowledge, it's true. The answer was verified by your town attorney. His signature was notarized by who? Jennifer Craig, the woman who called me. Think of the irony of that. You're claiming you have no knowledge of these communications, and the person who called me about it and communicated with me is verifying that it's true by the town attorney's signature. How do you sleep? Exhibit 11 is a stipulated order. Hearing was supposed to be held before November 1st, 2024. It was supposed to be held after 10 days' notice, accompanied by all the documents and information we have requested. From the date of that stipulation until, last week when we came in here, it's been like getting a truffle from a pig to get you guys to give us this hearing and give us the documents. As a matter of fact, they didn't give us the documents until November 13th. And I suspect the only reason they gave us the documents in November is because I had filed in order to show cause to hold you in contempt for not giving us the documents. And then suddenly we got the documents after that. Page 61 is my affirmation that was filed in that show cause order. Paragraph 10, 11, and on the next page, 12, 13, 15, and 17, all document the dates and efforts we made after the court ordered you to have the hearing and provide the documents. All the attempts we made to get you to do that, and the difficulty we had getting here. Exhibit 13 is a list of the documents that were provided to us on November, I think it was 13th or 14th. I received a thumb drive in the mail with these documents on them. You'll notice that under paragraph 4, where we asked for all correspondence to or from the town regarding merge, nothing. Nothing was contained in that set of documents. Absolutely nothing. Exhibit 14 are copies of my emails regarding the missing documents. And importantly, on page 73, which is hard to read because it kind of bleeds into the writing, but is the last page of Exhibit 14. On November 21st, I sent an email to Town Attorney Tom Fowler saying, look, we didn't receive anything for item 4. And we didn't receive information on item 5. So what's going on? I received back an email, page 75, from someone in the offices of Clucci and Gallagher, your outside attorneys, which says the town has conducted a diligent search of all electronic and paper records and was not able to locate anything further. Now remember, we're asking for the invoices from Merge for the last 3 years. You don't have any. You're telling us they don't exist. Merge has not been giving you invoices for 3 years. And you want to take away my client's license because he was late for 6 weeks after the blizzard? When they were trying to clean up his whole operation? Yet Merge, the company you're using to replace him, doesn't file any of these. Doesn't file them at all. And you don't seem to care. I mean, I don't have anything to prove this, but I got to tell you right away, my whose cousin is the owner of Merge? Because something's going on here. That doesn't make sense. Again, page 79, more email concerning the missing documents. And again, on November 22nd, Paul Joyce now, an attorney over at Clucci and Gallagher. The town has conducted a diligent search and the response is complete. Again, affirmation, you have no invoices from Merge. So now that brings us to discussing the actual violations. Exhibit 15 is a copy of the entire tow violation letter given to us in November. Again, I think it was November 13th or 14th, regarding why you were revoking Just Tow It's license. And it says that this is why you did this back in January of 2023 or 2024. And remember, you're giving me this 11 months later, claiming, oh, this is why we did this in January. Me being a little computer nerd, let me look at the metadata on that document. Lo and behold, look at Exhibit 16, page 89. That document wasn't created until November 11th. Those weren't the reasons you pulled this license. You made these reasons up in November. These are not the reasons. And we can prove that by the metadata in the document itself. Someone sat down in November and said, oh, we got to come up with something to explain why we're not giving him this license. And so you made it up and you provided this information. When we go through this, you'll realize how outrageous these claims are, that whoever made it up didn't spend much time thinking about it. Now on page 90, I have a copy of the first page of the tow violation, and I've included it with the provisions in the town law to, again, make the point, it is not the chief of police call. He can recommend to you that you not renew or that you revoke a license, but he does not make the decision. Under both the town law and the New York State law, you have to make that determination after a hearing, not before, and not because he said so. You have to exercise your discretion. It's not his discretion. He has the authority to tell you what he thinks you should do, because you've given him the authority to administer the law. But he doesn't make the decision on who a town toller is, just like you had to pass the resolution to appoint him. He doesn't make the decision on who the town tollers are not going to be. You have to make that decision. First violation I want to address. This goes to the employment of the felon. And this is where we're going to get into the details on this. The violation claims Mr. Mustafa employed a tow truck driver who went on an authorized Cheektowaga police town toll calls while not being authorized by 241-6, that's the reference to the we don't give these licenses to anybody who's a felon. Richard T. Krajewski, I believe his name is, would not have been authorized as a town toller since he is a convicted felon. Not because we went through the 8 factors and we determined that he would have fallen into one of those 2 categories that allow us not to hire him, just because he's a felon. Complete violation of New York State law and federal law, by the way. We're going to get into that soon. But there's some more interesting background to this. His fingerprints were given to the police in early July. If you look at page 93, you'll see a copy of the New York State Division of Criminal Justice Service report regarding this particular individual. And something else I want to tell you, by the way, this is also a little bit ironic. See on those pages, the blackouts? Those are mine. You know why I did that? Because you improperly gave me this sheet with his social security number on it. You wouldn't give us the FOIL information you're required to, but when it came time not to give me something you shouldn't, you did. It's unbelievable. Is anybody over there at the Freedom of Information Law handling this matter actually applying the law? So all these dark blackouts you'll see throughout this document are ones I put in there because you didn't do your job. So on July 5th, 2023, this report starts on page 93 and continues on page 94 and 95 and over to 96, where I've highlighted the particular determination that in June of 1999, this tow truck driver, who by the way had been driving tow trucks, it wasn't his first tow truck job, he was successfully driving tow trucks before he came to work for my client. He was convicted of a Class C felony robbery 25 years ago. He was charged with a Class B, but he was convicted of a Class C based on a plea. Remember that, Class C felony robbery. We're going to get into that. But interesting, the chief of police doesn't run over to Mr. Mustafa on July 6th, July 7th, July 8th, and say, Mr. Mustafa, you're a felon, you can't employ this guy. No, he waits until August 31st, almost 2 months later. Something so important to the town that they have a felon who's towing cars, we got to stop it, isn't important enough to come out there until 2 months later. When they come out to Mr. Mustafa and say, again, you'll see the blackouts, mine, because your Freedom of Information officer didn't know enough to do it. And they say, we got to have him sign this form, this application, so we can make this determination that he's a felon official. And they actually tell him, don't fire him yet, don't fire him yet, wait till we get this form signed. Is that correct, Mr. Mustafa? Confirming it, shaking your head yes for the court reporter? You need to speak up when I ask this, Mr. King. So they complete it now that they've got his signed authorization to go ahead and check on him, and they complete it, and they tell Mr. Mustafa, don't let him tow any cars in Cheektowaga. Complete violation of the law. Section 296 of the Executive Law. Shall be an unlawful discriminatory practice. This is at page 98. For any state, any political subdivision thereof, to deny any license or employment to any individual by reason of his having been convicted of one or more criminal offenses, when such denial is in violation of the provisions of Article 23A of the Correction Law. So that doesn't mean that you can't say we're not going to hire a felon, but you have to do it in accordance with Article 23 of the corrections law. You have to apply the requirements of Article 23 to reach that conclusion. And the reason for that is pretty obvious. This law came into effect 25 years ago, 50 years ago, I think it was 50 years ago, I'm sorry, 50 years ago. The reason was because the governor at the time said, you know what, we spend a lot of money incarcerating people and trying to rehabilitate them. And then the next thing we do is we throw them out in society and nobody will hire them. And they go back to crime. We need to stop that. So that's why this law exists in New York, to stop that from happening, to hopefully those criminals, yeah, sure, those criminals are never going to reform, they're just going to remain criminals. But there are many who will not, who will reform. And that's the purpose of this law, is to give them the opportunity to do that, without simply being tagged as a felon, therefore you can't work for anybody. Section 296, Section 6 imposes liability for a violation of it for anyone who aids or abets a violation of this law. So you might say, well, gee, it's not us. We're actually not employing this driver. It's Mr. Mustafa who's employing him. We're just encouraging him. We're just telling him, not encouraging, we're telling him, don't use him on any of our stuff. Well, you know what? Griffin versus Siva, New York State Court of Appeals case, 2017. Allied Van Lines told one of their contractors, you can't hire any felons. And so the contractor fired a felon. The felon sued Allied Van Lines. And the court said, yeah, Allied Van Lines, you're not the employer. You're the aider and abetter. You required your contractor not to use him under penalty of not having a contract with you. That's aiding and abetting a violation of the law. Same thing the town did. We went up to Mr. Mustafa and told him not to use that particular individual. Now, under Section 23 of the correction law, which is what you have to apply, you cannot deny employment or a license unless you can conclude one of two things. There is a direct relationship between one or more of the previous criminal offenses and the specific license or employment that the person seeks, or the issuance or continuation of the license or granting or continuation of employment would involve an unreasonable risk to property or safety or welfare of a specific individual or the general public. Now, those two criteria, you can't just say, well, we conclude them. No, you have to apply the factors in Section 753 to get to those two. And we're going to show you that neither of those factors would have any application to a tow operator convicted of a Class C robbery 25 years ago. Factors to be considered, listed in 753, is on page 100. Most importantly, item C, the bearing, if any, the criminal offense or offenses for which the person was previously convicted will have on his fitness or ability to perform one or more of such duties or responsibilities. I highlight that because further in the materials, and I'll give you the reference for it, the federal government, you know, all these tow truck drivers have a commercial driver's license, CDL. That's issued by New York State, regulated by the federal government. But if you want to haul hazardous waste, if you want to haul nuclear waste, if you want to haul biological waste, you have to get an endorsement from the federal government. The federal government has regulations on what CDL drivers can and cannot get that endorsement. One of those regulations say, if you've been convicted of robbery in the last 7 years, we may deny you that endorsement. The last 7 years, not the last 25. That driver could have gotten an endorsement to drive a truckload of nuclear waste through the middle of Cheektowaga. There isn't a damn thing that the chief of police could have done about it. Because the federal government doesn't believe that a 25-year-old robbery conviction impacts on a CDL driver's license. That's why you wouldn't have been able to conclude that it does. And the law specifically mentions the time which has elapsed since then. So when you don't apply the factors, when you never apply the factors, what you have is the police chief making a determination that Mr. Mustafa should have his license revoked for employing a felon. That determination is itself arbitrary and capricious because he didn't go through the factors. Never paid any attention to it. You lost that case in Cheektowaga versus Amico. Amico got a permit to open a car wash.
that the town board tried to revoke subsequently, unlawfully, without any basis for it. The court said that's arbitrary and capricious. Your determination to revoke that permit was arbitrary and capricious. Give it back to him. But we have an even better case. Matter of Acosta versus New York City of Education, 16 New York, 2011. 16 New York 3rd, 309, 2011. I say that because I'm used to, in court, judges always want us to give them the citation. I realize it's not important, but I'm sorry for that. In that case, the Cook Center was a private not-for-profit organization that provided preschool education. Remember, preschool education. We're talking about 3, 4, 2-year-olds. Preschool education service to New York City under a contract with the Department of Education. The plaintiff had been convicted of robbery more than 10 years before she began work for the Cook Center. When the Department of Education found out that she was convicted of robbery, a felony, they told the Cook Center, you have to fire her. We will not allow you to engage her employment servicing us. And so they fired her. And she sued, not the Cook Center, because the Cook Center was told, you gotta fire her. She sued the Department of Education. Again, because they aided and abetted. And the Court of Appeals determined that the Department of Education didn't bother to look into the factors, just applied a blanket, no felon rule. And on page 102, the last paragraph, I'm going to read it. A failure to take into consideration each of these factors, results in a failure to comply with the correction law's mandatory directive. It's mandatory, it's not optional. You don't have the option of ignoring it, it's mandatory. That was the holding of the State Court of Appeals, our highest court. Page 103, again, I repeat. Paragraph 14 of the town tower letter, highlighted at the bottom of the page. Your firm will comply with the provisions of section 290 and 299 of the executive law and the New York State Civil Rights Law. Yet you go out and you tell him to violate it. He's obligated under the authorization letter to follow it, but then you go out and you tell him to violate it. And you tell him, if you don't violate it, we're pulling your license. Page 104 has the code section, 49 CFR, regarding the 7-year rule for convicted felons for robbery. And then page 106, beginning on page 106, and the important content is on page 108, but I've included the entire document. This is the Equal Opportunity Commission for the United States. They are in charge of enforcing Title VII of the Civil Rights Law and equal opportunity in employment. They have an example in their materials, in their ruling. I've reproduced it on page 108. It says countywide, but just put in town of Cheektowaga. Example, state law exclusions not consistent with Title VII. Countywide, or county-wide, enforces a law that prohibits all individuals with criminal convictions from working for it. Now look at the conclusion, the last sentence. The county cannot justify rejecting everyone with any conviction from all jobs. Based on these facts, county-wide law purports to require or permit the doing of an act which would be an unlawful employment practice under Title VII. You're not only violating New York State law, you're violating Title VII of the Civil Rights Law. And you want to pull his license because he had hired a felon when you don't have any authority to require him not to. So that allegation is gone. It's off the table. You have no basis for it. There's no justification for it. If that were the only allegation you had, you couldn't pull it. You would have be completely arbitrary and capricious in an attempt to pull his license. Now let's get on to the next allegation. Exhibit 18 it starts at, page 109. Alleged violation, towing letter authorization, provision 15. Go to page 110. I'm going to pull a video on this to show you this. This allegation concerns an incident Mr. Mustafa, his wife, and his brother-in-law were involved in. Mr. Mustafa is driving down Broadway, correct? Trying to make a left to the entrance ramp that takes you to Harlem Road. And he's got the green arrow, and he's trying to make a left, and a car comes and hits him All right, auto accident happened. He's not engaged in towing. This is just a private, we're not engaged in towing, right? Just private, day out, doing whatever he's doing. The car that hits him takes off. Hit and run. He's a victim. Violation. The owner of Just Tow It, Youssef, was involved in a hit and run. Yeah, he was involved in a hit and run. He's the victim. So he starts chasing the guy. Under New York State common law and under statutory law, I think it's section 140 of the penal law, we still have citizens arrest in New York State. He's entitled to chase down that criminal. He's a criminal now, hit and run. I say criminal in the sense that accused criminal. He's entitled to chase that accused criminal down and arrest him and hold him for the police to come. He's entitled to do that by the penal law. He's not just doing it on his own. He calls the police and says, I just got an hit and run. Here's where we are, here's where we're going. And they tell him, okay, but don't drive recklessly. He says, all right, I'm not going to drive recklessly. He's following the guy. The guy turns down Dale Road. I don't know how familiar you are with Dale Road, but it kind of ends in like a semi-industrial area, just a bunch of fields. And he knows that. So he starts driving down Dale Road real slowly, concerned that he knows the dead end, the guy might start coming back at him. He doesn't want to get into a head-on crash. And as he gets to the end of Dale Road, he sees what the guy has done was realize he can't go any further, and this perpetrator of this crime is trying to do a three-point turn and get out of there. And he backs his car into a tree. Mr. Mustafa pulls his car up against his. Doesn't ram into him, doesn't hit him, pulls it up so he can't get out. Unfortunately, Mr. Mustafa's brother-in-law, who's in the car with him, jumps out of the passenger side of the vehicle, goes over to the driver's side of this car, opens the door, and starts engaging with the driver. Mr. Mustafa knows there's a police car right there. A police officer was parked at the end of that road. I don't know why, I don't care why. It's irrelevant. He was parked there. Now, he was parked facing away from the road, so he's only seeing the events in his mirror to begin with. And you'll see on the video, he jumps out of his car. Mr. Mustafa jumps out of his truck. He's on the other side now. So to get to his brother-in-law and get him from engaging with the person, he has to jump over the hood of the car. And he does it. You'll see him do it in the video. Very slowly, by the way. Nothing like you saw in the movies. He gets to the other side of the car, and he grabs his brother-in-law to pull him off. At the moment he does that, the officer has now reached the two of them, and the officer tugs Mr. Mustafa off. And they both come away. And the officer says, you guys go over there. I'm going to talk to him. Fine. And they listen to him perfect. No problem whatsoever. They go, and they go sit in their car. And the officers then begin engaging with this hit-and-run perpetrator. The hit-and-run perpetrator, no license, no ID, no insurance card, no registration, nothing, not a bit of ID. Doesn't even speak English. The officer has to communicate with him first. The guy calls somebody who is bilingual, and then the officer is trying to use his, I think it's a bilingual software they have on their phones. He's trying to use that to communicate with the guy. They finally figure out his name. And you'll see in the video we're going to play in a minute, the two officers discuss whether they should call Border Patrol. They decide not to. Now, I don't have any issue with that, but obviously you got a person who can't speak English, has no ID, and they check and they get nothing back. They say right on the video, nothing, no information whatsoever. We can't even confirm that's his real name. So ultimately, they have him call somebody to come pick him up because they're going to tow his car because it was involved in a hit and run. And they give him a ticket for leaving the scene of an accident, driving without a license, no insurance card, no registration, all problem. They couldn't arrest him for any of that. It's unusual in New York State law. If you have a license and it gets suspended and you get caught driving, you can be arrested. But if you never had a license and you get caught driving, you can't be arrested. You can only be given a ticket. So the officer properly doesn't arrest the guy, he gives him a ticket because he has no idea. This guy can't confirm who he is, can't even look up if he had a license. All he knows is he doesn't have one, and he can't communicate with him. After the event, and you'll see in the video, by the way, the officer discussing that Mr. Mustafa pulled his car up to prevent the other car from leaving. This letter of allegations claimed that he smashed into his car. He didn't. There's a lot of damage to that other car because that car hit Mr. Mustafa's truck back on Broadway. Mr. Mustafa just pulled his car up in front of him so the guy couldn't leave. And the police officer who was there, who saw it, says that's what happened. You'll see it on the video. So this allegation in this letter that he smashed into it, absolutely false. By reason of your own police officers who were at the scene. I don't know who wrote up this letter, but apparently it wasn't any of the police officers at the scene. And the officer acknowledges and thanks Mr. Mustafa for intervening in his brother-in-law's improper engagement with the driver. No allegation that Mr. Mustafa was engaged in any assault. You should have called him in here and given him a citizen's award for that. For helping a police officer stop an assault that shouldn't have been occurring. Not accusing him of being the assaulter and then trying to take his license. I don't know if this makes a difference in the decision to pull his license. I don't know that, but I want to highlight the fact that in the police reports for this, no mention is made of the perpetrator's ethnicity or anything else about him, just that we don't know who he is. He's got his name, that's it. But the police report mentions Mr. Mustafa's brother-in-law's ethnicity. SUS, meaning the suspect and the fact that the brother-in-law was engaging with, is from Pakistan. I don't know, I don't think I've ever been the subject of a police report, but if I ever was and I saw it said Gary Bork is Polish, why are you putting that down? What's that got to do with it? I just don't get why that's in there. Perplexing, given that the next page, 113, there's no information on this suspect. And there were pictures of, on page 114 and 115, which aren't all that relevant now because we're going to show the video. Let me get the video up. First, I'm going to play an abbreviated video that shows you the beginning, middle, and end. Then we'll play a little one that's 10 minutes long that gives you more context to everything that happened. But these are the critical parts of the video, the first part. It's only a couple minutes long.
I went to Dubai.
back off! Back off! Back off! Back off, man! Back off! What the hell's going on here? All right. Are you okay? Hey, go back. I'll talk to him. He may have very well just like inched up to box him in because he was trying to flee the scene again. I don't know if he saw me sitting here. Well, Ray Mitsubishi was spinning trying to get away. And I don't know if it's because he knew he was going to get a beating or if it's because he was just fleeing the scene again. But either way, he was trying to get out from there.
At this point, I'm just dragging slowly behind him to.
Yeah.
And when I saw him here, I just wanted to block the road.
I got you.
Then I looked right, and he was standing right there. I'm like, yo, we are about to
Yeah, it was just
what
like
he did was
chance of
nothing that I could have stopped.
No, I got you. Yeah, once you saw me, you pulled him away. It's just, he could very easily be going to jail today. So.
Yeah, I appreciate you guys.
No, I got you. Yeah, once you saw me, you pulled him away. No, I got you. Yeah, once you saw me, you pulled him away. No, I got you. Yeah, once you saw me, you pulled him away.
Those are the critical parts that show you that my client did not engage in an assault. My client tried to stop an assault. My client didn't ram his car into the vehicle. He prevented it from leaving. My client was recognized by the police officer as having attempted to stop the assault by his brother-in-law. I'm not excusing what his brother-in-law did, but my client wasn't involved in that assault. This allegation is like claiming that a woman who's been raped was involved in a sexual assault as if she was the perpetrator of it. Absolutely, completely false and bogus. No basis whatsoever. No ability for you to rely upon that claim in this situation. Now I'm going to play the other 10-minute video just so you get more context to it. And you have the complete video, by the way. Remember, these are the clips I made, so you may want to see the whole video. Sit and watch the whole video and say, oh, Mr. Bark, you didn't show us this part. No, because I picked out the parts that are relevant to my client's case. So feel free to sit and watch the whole video before you make your decision. We've been given the whole video. I don't have any problem with the town showing you it. The town attorney showing it to you. We've had the whole video. That's why I made the clips.
Hey, back off! Back off! Back off! Back off, man! Back off! What the hell's going on here? All right. Are you okay? Hey, go back. I'll talk to him.
The joking, the police,
I'll talk to you guys in a second, okay? I'm only one person. All right, what's going on? Habla inglés? No?
a little bit.
Okay. Driver's license or no?
No,
Okay. All right. 94 radio, some sort of hit and run. It did get physical over here. Any more cars? No rush.
Yell that English.
Is it your girl? Ma'am? Miss?
Yes.
Hey, can you ask him if he has any idea on him?
No, I'm sorry.
Okay.
No, that was from this. He ran it with the lower spear and looked it up on the elbow. You see that? I barely touched it over here. I didn't want to mess up my car.
Okay.
I really just so you have to move.
You know.
No, I know that.
So.
I apologize to you.
Danzat is the first name, Saturnino is the last name, date of birth, allegedly his address and his phone number and his girlfriend's phone number.
Okay.
Girlfriend does not have insurance or registration inside the car, and it sounds like he probably doesn't have a driver's license.
Okay.
So, do we have all the names from everyone inside the car?
We don't have the names for passengers here.
Okay.
I'm only doing, this only really consists of, no, there's not gonna be any damage to the tree.
There's not damage to the tree.
He barely hit the tree at all. So I don't have property damage other than the two vehicles involved.
Right.
So for
The original complaint.
the Walden one's gonna be a 104A.
Yep.
But was there anyone in the truck when it was hit? Yeah, at Target? No, I didn't, we hit on Harlem, right to Harlem from the road. That's where the accident was. So where does Target come in from? So he left, so I had to drive behind him. He wasn't driving recklessly yet, and I got his plate. I called the cops, and then he turned down this, whatever it was. I knew it was a dead end, I knew we got him there. Okay. And that's when I called, and I said, we're getting away off the Target, next to Target. I forgot what it was called. Somebody just punched the car in the Target.
No idea. All I know is
So this was Harlem Wall? Yeah. Okay. How did he hit you at Harlem Wall? We're out of Broadway. We're making a left to enter Harlem on that ramp. And that's what I'm doing.
And then you're doing a 104 accident change and all that? Did you look him up? Does he have it?
There's absolutely nothing in the system.
Yeah, I figured.
So if that's...
You know what though? Since we're here, well, Border Patrol's gonna take a while. I'm not gonna get involved with it. He may have very well just like inched up to box him in because he was trying to flee the scene again. I don't know if you saw me sitting here.
So he never started going forward towards the truck. The truck hit him against that truck.
Right.
Because that's why I went around.
Well, Gray Mitsubishi was spinning trying to get away. And I don't know if it's because he knew he was going to get a beating or if it's because he was just fleeing the scene again. But either way, he was trying to get out from there. Bueno momento, señor.
One way or the other, it's just going to be duplicate exchange for
Yeah.
We'll get the Ford out of here. If you want to have him back away from the car now, I'm fine with that. I'm not taking any pictures.
All right.
So,
All right.
get the bell running.
All right. Hey, my man, can you back up a little bit for me? Just so we can... Appreciate it. I got you. You do got some scrapes and cracks and stuff like that, so...
I was really just trying to keep it from moving.
Yeah.
Like, smack.
No, I got you.
He might even maybe pull it up. I don't remember.
All right. Who's your buddy in the back here?
That's my brother. I was visiting from the country. I told him.
Where's that?
In Palestine.
Palestine? Okay, can you have roll that one over? Or can you roll that one? All right, does he speak English? No? All right. So he was this close to going to jail because at one point he wanted to press charges against him. All right, he's not going to do that anymore, but he needs to seriously watch it. You know, this is Palestine. We can't be doing that here. So just tell him now in my presence. So if he's got any questions, but I mean, he did almost get arrested today. Okay.
What's going on with this?
So he's probably going to be issued some tickets, all right? Officer Scaglione's a traffic guy. He's going to handle all that. We're towing his car because he doesn't have a driver's license. You guys will be free to go. He'll give you your change form before you can take off out of here. All right, and he'll do an accident form for it, and I'm going to do a police report for it. Okay?
I mean, I can't run these days and not go to jail.
No, so because it's property damage. So property damage is simply just a uniform traffic ticket. So I would imagine that Officer Scaglione is going to write him for leaving the scene of a property damage accident. If it was a physical injury, then yeah, there's a good chance of it. But with a property damage, they don't see it as super serious. So it is an additional ticket, and he'll have to answer for that or not.
No license, no get arrested for it?
No, it's an unlicensed operator. So if he was suspended or something, it'd be different, but he probably just doesn't have one. So as a licensed operator, same, just another traffic ticket. So if there was anything, I mean, I know it's not ideal and it sucks, your truck got hit, that's why we pay insurance and that's why we can't have people beating on someone else for property damage.
Does he have insurance at least?
So there is insurance on the car from the sounds of it, and Officer Scaglione will have the information when he gives you the accident exchange form. So you'll get all that and whatever, I don't know if, it doesn't matter if he personally has it, it's just if it's on the car or not, and from the sounds of it, it does. So as long as there's insurance, you'll be good. If there's not, that's another traffic ticket, you'd have to take him to civil court for it. So you'll get all of his information and he'll get all yours and we'll try to get it all cleaned up for you.
I appreciate that you were here. I felt like you were super lucky.
Oh man, it was just pure.
Right there. But you saw the end of it in their very first video before. I don't see anything in that video, and I watched the entire hour and 20 minutes, whatever it was, the entire hour and 20 minutes, that would justify pulling Mr. Mustafa's license as a town tower because of that incident. It was an incident that occurred, well, not while he was working. I could see if he started fighting with somebody when he was towing cars or something, but none of that happened. None of that happened. He wasn't engaged in an assault, he stopped an assault. Now, also included in that section of the alleged violations is a claim that Mr. Mustafa showed up at a accident scene trying to tow a car when he shouldn't have. And if you look at pages 116 and 17 and 18, those are maps. The first map on page 116 is a map he was given, Mr. Mustafa was given when he got the tower authorization saying, this is your territory. This is where you tow cars. The second one is a larger map of the towing districts, and it shows a square out in the middle of it where this particular incident occurred. That's on the border of Mr. Mustafa's location and the adjoining the territory. And then page 118 is a close-up of that area, so you can see. I'm going to ask Mr. Mustafa if you would come up and explain to the town board what happened in that case.
So when I heard it on the radio, I heard the call say accident coming off the 3030 onto Union Road, collided with a vehicle on Union Road. So when we got there, what happened was the car was coming down Union and a car coming up the 33, and it pushed into the other zone. But when we heard the call on the radio, it said call vehicle coming off the 33, so we thought that was our zone. And I know police department, well, I know after that incident, police department didn't like us listening to the radio. But prior to that, I've always listened to the radio, and I always get the calls promptly. And by the time we get the call from the town, and we're ready to go. We already heard it, it's in our zone, and we're ready to go. That particular one, I thought it was in our zone, and I heard it was in our zone, but the accident transpired and it went into the other zone. And I just gave the okay to my guys to go out there, and when we were on scene, everything was fine until the other tow department came. And we didn't complain, we didn't argue with anybody, we just left the scene. No fight, nothing happened. They just told us, hey, it's not in your zone, and we left. Nothing else happened. The other tow department company was mad that we were there, but realistically, nothing happened.
Again, I don't hear any reason that would justify pulling his license, entire license. What would you do? Suspend him for one call? You know what, Mr. Mustafa, we don't want you showing up, so we're going to suspend you for one call. We're going to give one of your calls to another tower. That might be appropriate at most, if anything. Now, that section of the violations letter also complained that Mr. Mustafa was calling the police department and inquiring about whether he was being treated fairly. My God, you're gonna pull somebody's license because he asked you if he's being treated fairly? If I go into the assessment department and say, hey, I don't think you're taxing me fairly. Well, you know what, we're gonna double your tax for asking that question. That's just outrageous. If your police chief can't respond to natural inquiries by these town towers or anyone else, he shouldn't be police chief, period. That's not a reason to pull someone's license because he questions him. Alleged tow violations. Exhibit 19. Paragraph 241-16, inspections. There's 2 violations here. 1, violation because he had a driver whose license was suspended on August 16, 2023. Mr. Mustafa was informed that that driver's license had been suspended. The reason that driver's license was suspended was because he didn't respond to a traffic ticket. I think it was a town of Orchard Park. Within 5 days, that driver went to the town of Orchard Park, straightened that out, got his license reestablished. Exhibit on page 122, the copy of the letter. License effective 8/31/2023, 5 days later. You're going to pull Mr. Mustafa's town tower license because he appropriately responded to a deficiency brought to his attention by... Mr. Mustafa isn't on the computer every day checking to see if his drivers have licenses. The police are doing that, and when they informed him of it, he promptly responded to it, took care of it. Same thing in that section of the allegation is that he had a truck that missed a registration. And as soon as he was told about it, he went and got it registered. Oh yeah, he shouldn't be driving a truck without a registration, but it was brought to his attention, he immediately took care of it. You're going to take his license away for that? Exhibit 20, alleged tow violation, audits and receipts. The violation says, paid invoices were not regularly sent to the office for an extended period from January 12th through March. It doesn't say when in March, I think it was early March. We're talking about 2.5 months. Mr. Mustafa says, look, I had an agreement with the police on this, but we just got through this horrible blizzard, and we're going to get into what Mr. Mustafa did for this town with that blizzard. And we're trying to clean up. I mean, it was just a horrible time for us. And we had an understanding we're going to be late with these. And so, yes, he was late with them. But he did provide them. He did get them in. Unlike Merge, who hasn't given you one invoice in 3 years. How do you explain that? Merge is out there towing in his territory now, tonight, without giving you any invoices for 3 years. But because he was late with some invoices after that horrible blizzard we had, we're going to take away his license. Alleged toll violation, fee schedule. 3 items were brought to Mr. Mustafa's attention in which the police department said, hey, you overcharged these people. Because remember, the invoices go to the police department weekly. Unlike Merge, Mr. Mustafa is sending his in weekly. Police department finds 3 of them that they say are overcharged. One was for $55, one was for $128, and then the other one was for $400. Oh, I'm sorry, $125, $55, and $415. Mr. Mustafa had trouble getting a hold of these people. The one for $415, correct me if I'm wrong, Mr. Mustafa, but that's the one that he got reimbursement for. The issue was the driver actually got reimbursement for that from his insurance company. So it was a question of whether or not it should go back to the insurance company or should go back to the driver. Eventually, Mr. Mustafa resolved it all and said, you know what? The chief of police said, we're going to pull your license if you don't resolve these. He said, okay, the hell with it. I'm just going to give the guy the $415, let his insurance company go after him for fraud. I don't want to lose my license. Again, he responds appropriately. A little bit late because of the circumstances, because he was trying to figure out. One of these, Mr. Mustafa tells the police, I can't get the guy to respond. I can't get a hold of him. The response by the police isn't how to get a hold of him. It's, well, we got a hold of him with no problem. Well, let me tell you something, folks. My house, I got a Ring video camera. I see a salesman from Anderson Windows knocking on my door. I don't answer the door. I see a police officer from Cheektowaga. I answer the door. That's why he answered the phone call from the police, but wouldn't answer Mr. Mustafa's phone calls. And you'll see pages 133 to 139, all the processing and emails by Mr. Mustafa and the police department regarding those matters taken care of. Exhibit 22, page 141. Alleged tow violation. Release of vehicles. 2 vehicles at issue here. The first one was released on September 21, 2023 by Just Tow It without the Cheektowaga police release. That's the allegation your chief of police is making in this document. Those aren't my words, his words. However, on the next page, 143, you'll see that Officer Caitlin Nowak, badge number 676, signed the release for that vehicle on that very date. And on the next page, you'll see that originally that vehicle was on a 12-hour hold, and it wasn't released until 12 hours and 15 minutes. We have the chief of police accusing my client of releasing a vehicle illegally when the chief of police didn't check his own records to find out that one of his officers told my client, go ahead and release it. Here's the form. You want to take away his license for that? Now the other vehicle, we don't know what happened to it. Mr. Mustafa couldn't find any documentation for it, couldn't find anything in his records. So it's possible it wasn't properly released. Again, sufficient to take away his license. You got a police chief who doesn't know he's authorizing his officers to release vehicles and accusing people of illegal releasing it. Now you want to take away the man's license because he made a mistake? And may have released 1 vehicle out of how many that he's towed over the last 3 years? Now, Exhibit 23 are Mr. Mustafa's notes that he originally wrote about each one of these allegations. I encourage you, I'm not going to read them here, I encourage you to read them before you make your decision. If you need further information about why these allegations do not amount to a hill of beans when it comes to revoking his license. So now we get to the proportionality. New York State has a long history in cases such as this regarding licenses that even if you have some justification for disciplinary action, that disciplinary action has to be proportional to the violation. And we've shown there's no assault. We've shown there's no improper release of 1 vehicle. We've shown that the attempt to get him to violate the law is improper on your part, not his part. Never should have even. All you have is a possibility he released 1 vehicle and he was late filing a couple of receipts, which he had an agreement about, and there were 3 invoices that were disputed. That's it. Proportionality doesn't amount to taking away his license. And there's 2 cases I cite for you on page 156 that address issues similar to this, but I want to get into some specifics now. And these are going to be painful. When you consider the proportionality of any punishment you think Mr. Mustafa should suffer for those minor instances, I want you to think about what happened to Officer Rogers, police officer for the town of Cheektowaga. January 14, 2018, at 1:40 in the morning, police officer Rogers was at a bar in West Seneca. By the way, this is from your official reports. This is not my writing. I'm taking this right from the information reports that were provided by the police department to Gannett newspaper. Around this time, an assault occurred where 1 patron hit another patron in the head with a beer bottle. According to reports, witnesses, and Rogers himself, when the suspect in the assault went out the door to flee, Rogers went out the door after him. Fleeing suspect, citizen arrest. Officer Rogers and the other patrons are doing exactly what Mr. Mustafa was doing when he chased down that hit-and-run perpetrator. Additional persons not involved in the assault also left the bar. to chase after the suspect. Rogers and the bar patron eventually caught up to the suspect near the roadside at the corner of Orchard Park Road and Michael Road and tackled him in the snow. Now this is in West Seneca, not in Cheektowaga. Rogers is a police officer in Cheektowaga who's out drinking that night, not on patrol, not violating any rules. He's entitled to go out and have a beer if he wants, there's no problem. But he's not out there as a police officer, he's out there as a citizen. According to witnesses, when the police arrived, they ordered Rogers and the other patron to get up and off the suspect. Similar to what you saw in the video. Hey, 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 get off there, yelling at Mr. Mustafa's brother-in-law. According to the West Seneca police officer's written report, and the other patron immediately got up, but Rogers did not. Unlike what you saw in the video, where even Mr. Mustafa's brother-in-law obeyed the police, Officer Rogers did not obey the West Seneca police. The other patron and another witness interviewed stated that the West Seneca officers had shown up in marked police cars, were in uniform, and identified themselves, and that anyone would have known they were police. This is from your own report, not mine. West Seneca police reports written by 3 different officers on the scene stated that Rogers was ordered multiple times to get off the suspect and refused. The reports state that after Rogers refused to get off the suspect, the West Seneca officers physically pulled Rogers off the suspect, and they immediately, after doing so, Rogers turned on the officers, grabbed onto their legs in an apparent attempt to tackle the officer. The officers were forced to subdue and handcuff Mr. Rogers. And they put him in a police vehicle. They took him to the West Seneca Police Department. He continued to act erratically, yelling all kinds of things, etc. When they determined he was a Cheektowaga police officer, they called the Cheektowaga police, who came over and gave Mr. Rogers a ride home. Now, I have no complaint about it. I know a lot of people are going to say, well, the police officer gets a ride home, anybody else would go into the hoosegow. But I'm okay with that. That's not our issue. Our issue is compare those facts to what you saw in that video and what the chief wants to pull Mr. Mustafa's license for. And then let's find out what the punishment was for Mr. Rogers. After a full investigation went on for about 20 pages, on February 19th, 2018, they sent, Police Chief David Zack sent Officer Rogers a letter of suspension, citing 3 different sections of violation. One had to do with compliance with Code of Ethics, Department Mission and Values. And remember, they're claiming that because Mr. Mustafa engaged in a citizen arrest, he somehow negatively reflected on the Cheektowaga Police Department, even though at the time he wasn't doing anything. He wasn't towing or anything. But the chief says, well, that reflects negatively on us. Here they're saying, yeah, you know, Mr. Rogers, what you did reflect negatively on us. Section 2, general conduct, conduct unbecoming professional. And Section 3, conduct, comprehension, and obedience to laws, ordinances, rules, and orders. Specifically, obstructing governmental administration, 2nd degree, disorderly conduct and harassment, 2nd degree. So this is what the chief of police said Mr. Rogers had engaged in that activity. I want you to compare that to what my client engaged in. The punishment for this, and again, I don't have any dispute with the punishment. The punishment was 20 days suspension against accrued vacation pay, 20 calendar days, not 20 work days, 20 calendar days. So he lost something. He lost some accrued vacation time. Never lost a day of work. Lost some accrued vacation time. How many days he would have worked during those 20 days, we don't know. I don't have a dispute with that. I just say compare that proportionality. Take that decision and compare it to the decision that your police chief now wants to make against Mr. Mustafa for these alleged violations. Another proportionality. In 2012, I believe he was a captain at the time, Zelinsky, ran over a woman at 11 o'clock in the morning, 12 o'clock, 12 noon, broad daylight. She had an orange blouse on, ran her over. cost us $900,000. Cheektowaga taxpayers paid $900,000 for that accident. Again, accidents happen. I'm not criticizing Chief Slawinski because of that. He became chief eventually. At the time, he was a captain. He was promoted to assistant chief and became chief. That's why we have insurance. That's why we do the things we do in regards to protecting against liability. Accidents happen. It was an accident. But he did cost the town a lot of money, and he did violate the law in running her over. And so the department felt it had to impose some penalty. The penalty, 3 days suspension without pay. Okay, no problem. But compare a $900,000 judgment to anything Mr. Mustafa might have cost the town, $455 for the one receipt. And you want to take away his license when you give a 3-day suspension to a police officer that runs over a woman in broad daylight. Interesting, by the way, the suspension was served beginning on December 23rd, so he got to sit home 23, 24, 25 in December. If you're going to suspend somebody, that's a good time to do it. And then lastly, not involving the police. 2011 to 2013, we got a lot of hanky-panky going on in the town of Cheektowaga. Auditor comes in, comptroller, New York State comptroller comes in and does an audit. And the New York State comptroller says, whoa, you guys got problems here. You got questionable contracts, you got questionable expenditures, you got a lot of nonsense coming on that requires you to correct it. But one of the things that the comptroller concludes, and this is on page 167, payments included more than $635,000 for services unrelated to the original project scope, such as curb restoration work and installation of new concrete curbs, which were not competitively bid as separate projects as required by law. This is the New York State Comptroller talking about town employees. Town officials paid more than necessary for 121,000 square feet of sidewalk installation without a valid explanation. And then the final sentence on that page, 167. In fact, the total cost would have been $12,000, saving town taxpayers approximately $600,000. And the last sentence nails it. This occurred because the town engineer failed to exercise proper oversight over the construction contract bid process or adequately supervise the management of the projects. That cost us taxpayers $1.2 million. Punishment? Nothing. Not a day of suspension, not a day of lost pay, not a benefit loss, nothing. In fact, the supervisor at the time, Mary Holtz, tried to defend them. Not only didn't punish them, went out there and tried to defend them in the news. Oh, we never do that with our contracts. Even though the state comptroller said to do so. I don't see how you punish Mr. Mustafa for any of these allegations, even if they were all true, in light of those relative instances. I want to try and close on something positive. Exhibit 26. This has to do with the Blizzard video. I'm sure you've all seen it. I'm not going to play it here. I didn't bring it anyways. You've all seen the heroic efforts of our police force out there during the blizzard, checking on cars, making sure people weren't dying in those cars, and doing a heroic job. It was a wonderful video. At the end of that video, on page 169 of the documents. At the end of that video, a screen pops up, and at the bottom of the screen it says, thanks to the fleet of tow truck drivers who moved close to 500 abandoned vehicles to designated emergency toll lots. Entirely appropriate by our police chief at the time, Chief Gold, thanking the tow truck, licensed tow drivers who were out there in that storm. Now I want to tell you about that. You see how bad it was when the police went up in the videos and knocked on doors, how cold and blustery, and I even went out to, you know, how horrible it was. A tow truck driver, to get a car out, had to shovel. Get out a shovel and shovel. Had to drag the car up the ramp because they didn't have keys for the cars. And then when he got to the tow location, the drop-off location, had to get out and jiggle the car off the ramp and try and slide it down because they didn't have keys, couldn't put it in neutral. They spent an hour to an hour and a half with each car out there in that cold. And Mr. Mustafa was one of them. In fact, he was the primary one. The rest of that exhibit contains copies of all the cars he towed. They total up to 138 of those almost 500 cars, not even 500. He did 30% of the work over that period. On call. When other town towers were, we can't get anybody to come in, it's too cold, let Mr. Mustafa do it. And he did it, and he did it well, and he did it with people sleeping in his location overnight. And he worked his butt off for the town of Cheektowaga. The thanks you should give him is an award of merit, not a revocation of his license. I'm going to ask Mr. Mustafa to address you with regard to all the work he did on his property from the day he first applied for his license until its condition now. Would you come up and tell him about that?
In order to get our town license, we had to have a lot that was zoned for impound and a building where we can keep our operate our business. At the time being, we applied and we were renting. When I tried to apply, we found that Miller's Towing was trying to get out of the business. So we had to buy their property, and it was already a Cheektowaga impound lot, so it worked out perfectly. They wouldn't give us his license, so we had to apply, and we got it because we bought the property. And when we bought the property, it wasn't in the best condition. And me and my brother, we put a lot of money into this business, just in buying the property and fixing it and making it look presentable like the town code says we have to get the license. We spent nearly $1 million. And we did that gladly because this used to be this was a modest amount of money was to be a town tow, especially in the town that I was raised in, majority of mine. So we spent a lot of money, brand new trucks. Every time Sergeant Vibziak came to do his audit, he always used to notice the work we've done, inside, outside, everything. Maybe not was 100% to par, but when he told me that it wasn't, I'm glad he fixed it right away. And all we want from me and my guys is to receive towing to Cheektowaga. And any violations that you guys came up with, I don't think that they're just enough for us to get revoked. And I honestly we love towing, and that's what we do. So a little bit of paperwork is a little bit misplaced, or whatever the case may be. When it came down time to it during the storm, we were out there 24/7. I don't know if you guys remember, I think it was the 24th, the 25th, it was during Christmas time. My guys couldn't even go home. We slept at the shop, we took turns, we were out there, the first company to start towing. We were really the first company to start towing. There was companies that didn't show up until the second or the third day. Resiniac, so you guys know, they control the 90, and that was their obligation, was to first do the 90. They would have been out there with us, but they have an obligation to the 90, so we were already there, and we took care of the town. Up until everyone else showed up. Some companies never showed up. 2 or 3 of them just never showed up. And all 5 of our tow trucks, 10 of our guys, just round the clock. And we did the best we could. And all we wanted was just to tow for the time. And I appreciate it. I'll make a decision on that. Thank you.
I don't know if I heard, but you said you took over Miller's old?
Yeah.
Okay, thank you.
That concludes my presentation. If you have any questions, I'd be happy to entertain them. If not, then I guess we'll move on to whatever the town wants to do, and I hope you make a rational legal decision on the matter, and I hope what you'll do is understand that Mr. Mustafa's license should not have been revoked, reinstalled. He'll become a town tower again. We'll have to resolve the issue of
the outstanding balance before the court. That's a matter for the court, not for you. But as to him being a tower, he should be back towing tomorrow. Thank you.
Laura, I assume you're okay with the entirety of the board utilizing the binder you provided to make a determination?
Oh, yes, that's what we
Take it
provided.
with it, read it
Yep,
through,
yep, I want you to keep
everything
it, read through, look at it. You want to watch that whole video, go ahead. I know we didn't present it, but go ahead and watch the whole video. It's an hour or so long. All of it, go back and watch the Blizzard video. That's part of it, that's fine too.
And do you have any, we'll call it post-hearing submissions that you want to submit to the board for consideration, or?
Not unless I hear something else.
If they have questions?
Yeah.
Okay, thank you.
Yeah, I'm gonna make a motion to, actually, with those that are online, any comments from the chair? All right, hearing nothing. You might not say that. Any of those online wish to speak? Okay, hearing nothing, I'm gonna make a motion to close the hearing. Do I have a second? All in favor of closing the hearing?
Aye.
Any opposed? Hearing is closed.